The video system working? Okay, everybody, this is the Reeves Subcommittee of Judiciary Non-Civil, and we still have some members coming in. I believe that we have Representative Bodie online. Is there anybody else online right now that's a committee member? I know that we have some speakers on some bills that are joining us online. We have two bills that are going to be taken up that I anticipate, and my expectation is we will not spend much time on, and that we are going to dedicate a significant part of the afternoon on House Bill 327 and trying to get out as much testimony as we can on that matter. But right now we're going to call Chairman Bonnie Rich's bill, House Bill 94, and is LC 289958 the correct LC number? Okay, hang on. You should be live now. Can talk.
Yes, it
okay,
is.
Perfect. So let me give everybody a briefer here. This bill passed this committee and full committee last year, and Representative Rich was out for a bit, and so we didn't get it past that, but it did make it out of this committee. We did debate this issue last year. Everybody that's in the room right now, with the exception of Representative Lopez, has heard the debate on this and was involved in it. And this is the exact language, is my understanding, as the bill that we've already passed out a year ago. But why don't you walk us through just real quick the bill, the issue, the need for it? I know that we talked a lot last year about we have to adapt our laws to be consistent with crime as we see it and as it's happening, and as frankly in the last year the concept of Amazon and home delivery shopping is significantly more than it was a year ago, and so I imagine that this problem it's not solving itself. And so why don't you tell us about your bill on the issue?
Yes, thank you, Mr. Chairman. This bill was requested by our U.S. Postal Inspector. We have an epidemic of sorts with respect to mail theft. In 2020, they received over 20,000 reports of mail theft from citizens. There were an additional 95,000 reports of mail not received. A significant portion of those, the U.S. Postal Inspector suspects, were actual theft. The theft, when it occurs from a group mailbox, is much more obvious because the mailboxes are broken open. But when mail is stolen from a curbside mailbox, it's more often reported as just not having been received. So we have a significant amount of mail theft that is going on. Just this session, January 28th, the morning of 28th, the DEA executed a search warrant along with the postal inspector. They were pursuing pill pushers, and I passed out some of these photos to you. When they executed the search warrant, they saw that they had moved on from either moved on or added to their repertoire mail theft and parcel theft. So the photos that you see here in of all of these packages, they were found at a home in Stone Mountain, which is in DeKalb County. None of the packages had been delivered to a home in DeKalb County, so DeKalb County was not going to pursue the prosecution. The parcels did not amount to a significant enough value for the feds to prosecute the mail theft. So this is going to go uncharged. And he said this is not a one-off. This is just the most recent one that happened this year, but it's very common that this occurs. So going to the bill itself, this does create a new crime. The crime is theft by possession of stolen mail. And the reason for that is that these people are not seen in the act of actually stealing the mail. But when one is caught with a significant amount of mail that's addressed to multiple different people, this statute will allow them to satisfy the elements of this new crime. So a person who is found with mail that has been addressed to 3 or more different mailboxes or addresses and has 10 separate pieces of stolen mail will be guilty of a felony.
Well, they'll be eligible to be charged with the crime,
Yes,
right?
yes,
Okay.
you'll be charged with the crime, and if it's proven, they will be found guilty of a felony. The second portion is what's commonly referred to as porch piracy, and this also, as I said, was requested by the U.S. Postal Inspector, and this just provides that a person who steals a package from someone's porch steps or the immediate vicinity of any exit or entrance to their dwelling can be charged with the crime of felony. And these new crimes will provide for a penalty of imprisonment of between 1 and 5 years.
And just so that we're clear, that when it's 1 to 5, that can all be probated. Is that correct?
Yes, that's correct. Thank you. I had discussions earlier today with Representative Lopez and with you, Mr. Chairman, and I feel comfortable in stating in my place here that the 1 year is not a mandatory minimum, that it can be probated. And I am happy to take any questions.
The okay, I'm gonna say who's number 6? Is that Miss Representative Lopez?
Thank you, Representative Rich. I appreciate you coming before us today. And I know where you're coming from, and I know that we have to adapt and deal with issues as, currently, particularly during COVID. I know that we've been getting so many packages and so many, and this, has been raised to you. So my question is, so this would not be covered. So someone steals mail or steals a package from my porch. This is currently not covered under current law. Can you go and explain that?
That would be covered under our traditional theft statutes. So oftentimes, an example that was given was seniors oftentimes get their medication in the mail, and it may be a $6 item, although it's life-saving for them, and that would be a misdemeanor. And given the level of crime and particularly in our metro area communities and counties, that would not be prosecuted.
And I think that what's important, this is and I recall this from the discussion last year. What we're really looking at here is there's been obviously a drastic, frankly, there's been an industry that has more or less developed of stealing. I live in a really big neighborhood. I live as far in the back of the neighborhood as you can get. So we're in the back cul-de-sac. I have a lot of neighbors that have had this happen more than once. Luckily, we haven't yet because we live so far back in the neighborhood. I think my wife, we have something delivered every day. I mean, I don't know what it is, but I'm sure a lot of you have the same experience. But there is this is conduct that it's not considered burglary because there's no entrance into the house. But we're talking about something that could be prosecuted in a lot of cases if the value of the property is less than, what is it, 1,000 or
500? Is it $500?
I think it used to be 500, and didn't we raise it? But if it's less than than $500 or $1,000, which in a lot of cases what is being delivered to folks is, then it's a misdemeanor. We are seeing a dramatic industry develop out of this, and I believe that the culprits of this, it's a repeat offense type thing. I mean, this is usually not one-off type things. There are folks that are going and consistently stealing everything they can. And I think that what we contemplated with this bill is that because it really gets right up to the castle doctrine, the burglary, right? But it doesn't go inside the house necessarily. That's why it's not a burglary. But that in combination with the increase in this activity, that it was time for us to act in a more serious way, so that number one, hopefully we can begin to create a deterrent. I know that there's mixed debate on whether or not we actually do that, but the bottom line is that when somebody this is a more egregious type of theft, and it's out of control is what's happening. And as I recall from last year, we tried to craft a piece of legislation and a punishment system that was kind of on par with the egregiousness of the crime. Is that your recollection, Representative Rich?
Yes, yes, and it is a much more brazen act for someone to go right up onto the porch, onto the at the doorway and take a package. I think I was sharing with one of you this morning that my daughter is oftentimes at home by herself, and we have a glass door. And if she were to walk up and someone was right there at the door taking a package, well, who knows what could happen? And that's what makes a burglary more serious. And for the same reason, this is a much more serious offense. It takes a much more brazen criminal to do that.
That's right. It's this concept. We obviously have a lot of policy directed around the sanctity of your home and feeling safe. And frankly, I luckily haven't experienced this personally, but I have neighbors that have, and it completely changes your willingness to want to engage in e-commerce and order things online. And it's not just that somebody's having something stolen, but it's causing them to not want to engage in what has frankly become an extremely convenient and widely accepted form of retailing. And, so I think that this is a problem that deserves a serious solution. And I know that's what we contemplated last session. Is that Representative Momtan? Are you?
Thank you, Mr. Chairman. I just wanted to, I'm looking through this paperwork that you gave to us. I'll take off this mask so you can hear me. And on the, so it looks like second last page, we're looking at all the stolen goods as we go through it. Can you confirm that is a pair of bolt cutters, looks like a can of Fanta, and a Holy Bible?
The second to last page or the last page?
Right here.
Oh, the very, I do not know if that is a Bible.
Well, if it is a Holy Bible, just if I may offer a comment to the committee, if they spent more time reading that, I think they'd be in a little less trouble. Thank you for the bill.
Okay. I'm going to go back. Representative Lopez.
Just one last
Sure.
comment. I'm sympathetic of your idea, and I understand the intrusion. That's kind of what you're trying to convey when they come to your house. And I also have a daughter, and it's just, to me, I struggle with the creation of a new felony. And so that's kind of where I'm, and this is the first time, at least that I'm seeing this bill. And I, think about a teenager, going in and being, not using good, just going about doing these things and then being hit with a felony charge. That's, I'm struggling with that, but
yes.
maybe it's not for you to comment. I just want
No,
to.
I actually do
Okay.
very much need to comment to that
Okay.
because that was contemplated.
Okay,
And
perfect.
there are
Thank you.
protections that
Okay.
are written into the bill for that.
Okay.
If you'll notice on lines 22 through 24, the person has to possess stolen mail addressed to 3 or more different mailboxes and possess a minimum of 10 separate pieces of stolen mail. That's not a teenager going up and taking a package off of someone's sidewalk. That is someone who is involved in a crime ring. And there are multiple of these crime rings. And as you see from the photos I passed out, these are the drug dealers who are doing it too, because it's very profitable. And we don't really have a crime for it right now. Those photos of all of those packages that were stolen, that's going completely uncharged. That was a serious high-level crime ring, and there will be no charges brought against anyone for any of that. And I'd like to also point out that the U.S. Postal Inspector has informed me that this is a crime that disproportionately affects low-income people. It does not happen in neighborhoods like yours, Mr. Chairman.
It actually does.
As often as it
Yeah.
does in low-income
Sure.
neighborhoods.
Mhm.
It is a much
It's
more
happening
common-
everywhere. That's
Yes,
right.
but it's much more common in low-income neighborhoods, and especially the neighborhoods where they have collective mailboxes, because those are so easy to break into. And also in the lower income neighborhoods in the counties that are not prosecuting crimes of theft. There's really no deterrent at all for this. So poor people are having necessities stolen off of their porches and out of their mailboxes. And you'll also see they're having their checks stolen. There was a huge uptick when the stimulus checks went out. That was the target. Elderly people are not getting their medication. So this is a crime that it does significantly, disproportionately affect lower income people and the elderly.
Thank you, Chairman Rich. Is Representative Bodie have a?
Yes. Thank you so much, Mr. Chair. And thank you, Madam Chair, for your testimony today. Like my dear friend and colleague, Democratic colleague, Representative Lopez, I have some concerns as well, especially with Section 2 of the bill. And the reason why is that currently under OCGA 16-8-2, theft by taking, subsection C deals with basically taking an item that's valued at between $1,500 and 1 cent and $5,000, and that being a 1 to 5 offense. Now, with this particular proposed legislation, if we have what I call the Amazon scenario, and mind you, this is an issue, and I'm not condoning it, and because it happened to family members, friends, and constituents where their Amazon packages were taken from their patio, their porch, and if you have a package where the contents of that package were worth, say, $29.99, someone goes and orders vitamins from Amazon. Under this legislation, if that item is taken, that box of vitamins, that is now a felony. Now, under our current theft by taking statute, 16-8-2, being that the value is below $1,500, it would only be a misdemeanor. And so I'm having issues with the parity in the law right now, because I understand the need, but if we're going to be on accord and moving towards what we've been moving towards, a criminal justice reform in the state, adding an additional crime, and also adding an additional crime that would actually upgrade a penalty for an item that's less than the $1,500 that is currently the threshold for a felony, is going against what we did a couple of years ago. If you remember, Mr. Chair, $500 was the threshold. And the reason why we went up to $1,500 is because then Governor Nathan Deal submitted legislation so we could go up to $1,500, so we wouldn't have so many felony cases where the dollar amount was under $1,500. So I have concerns, and I think that section 2 really gives me a lot of pause. Thank you, Mr. Chair.
In Representative Bodie, let me say this. If you commit a burglary and if you break into someone's house and you steal a piece of paper, then that's a burglary, and that's a felony 1 to 20. And the value of the item that's stolen is not the driving factor. It's the conduct preceding that. And this, while it's not 1 to 20, it's 1 to 5. I think that we're looking at conduct that is more egregious than other types of thefts. You are absolutely right. We've done a heck of a lot in the last 8 years on criminal justice reform, but yet behaviors these are actually new behaviors. The criminal justice reform has not stopped, or has not contained, or has not caused a pause in behavior. In fact, what we've seen is, frankly, a new industry, a new criminal ring has developed. And it's serious, and it's affecting people in a different way than when, somebody leaves an item on a counter somewhere and somebody walks off with it, right? I mean, that's unfortunate too, but this is affecting people as far as their comfort in their home and their desire to have packages delivered. And I think that those are the driving factors that put this in a different category. I appreciate your comments, but we have a serious problem that our current law, most of these would be prosecuted as a misdemeanor right now, and it's obviously that it's not stopping the wave that we're seeing here with this. And so
Mr. Chair, can I say one last thing? Just
Sure.
one last thing. I'll be really quick. Mr. Chair, I agree with you, but the difference the difference that we have with your analogy is that a burglary is actually going across the threshold of someone's home or dwelling. And so when you have that threshold being crossed, I understand now we're dealing with a statute, a different statute. We're dealing with the castle doctrine. We're dealing with a whole different standard once the individual crosses that magical line. And I think until they cross that magical line and they do commit the act of burglary, which is a theft therein, you're right, it's no dollar amount. But if they're outside of that threshold and outside of that home or dwelling, theft by taking statute should still control. Thank you, Mr. Chair.
Sure. And, I'll give myself the last word on that. I have a 12-year-old, and our 12-year-old is left at home alone by themselves sometimes. And if this happened at my house, then I would be reluctant to leave my 12-year-old at home. If somebody came up to our door and stole something, then it would not just, it would affect the way that I look at having my 12-year-old left at home. And I think that there's a public policy message here that's extremely strong. Don't mess with people's houses. Do not trespass onto people's lawn and steal. That is a very strong public policy. And we have the willingness to violate that has gone wild. It has gotten out of control. And frankly, it's our job as a General Assembly to identify this, relatively new concept of crime ring and answer it. And so I believe, as we came to the conclusion last year, I believe we've arrived at an answer. And so with that, I will stand for a motion. Okay, there's a motion to pass. Is there a second? Okay, is there any discussion on the bill? Are there any amendments on the bill? Okay, seeing or hearing none, I'm going to call for the vote. All those in favor of the passage of House Bill 94 LC 289958, vote by saying aye. All opposed?
No.
Okay, so the ayes have it. And thank you, Chairman Rich, and you are going on to full committee on this. So
Do you have rules forms in there?
I don't know. Do we?
Oh, yeah,
That's right. Yeah. You're only halfway there.
That's right.
Okay, so I'm going to call Representative Gaines up now. We're going to House Bill 231, and Representative Wynn, please join and tell me what microphone number you're at, and I will. She's at 5. You're at 5. Okay. Okay, so this is our second hearing on House Bill 231, and I'm trying to find my old version of it. Here it is. Okay, so to get everybody up to speed, at our last hearing on this, we heard from Representative Gaines and many advocates and Representative Wynn, and what we wanted to do was we wanted to tighten up the concept of, and again, and this is, our job is to get as close to perfect as we can possibly get. And what we do, with the words that we pass into law is we create laws that are then subject to interpretation by different persons and by judges and by folks all over. And so this is one of those issues where we cannot spend enough time and effort trying to get this concept as close to perfect as possible. And one of the things that the wisdom of the committee discussed was the potentially ambiguous gap between, the concept of a dating and romantic relationship and a casual friendship or regular good old fashioned friendship. And that my understanding from the author's intent is that this bill is designed for people that are in a romantic relationship, and it's designed to give an avenue. And apparently Georgia right now is lagging behind many other states in that we do not have the option for a family violence TPO to be granted to people in the context of a dating or romantic relationship. And I think that the will of the committee is very much in favor of moving something forward. But the key that we're working on, and unfortunately, Chairman Setzler is not going to be here today. And he had a lot of questions and has had a lot of input on this bill. But that being said, we can still talk to this and see where we are on things. But what we're trying to do is make sure that the language that we have put in this bill is directed at the activity and conduct that we intend to prohibit by virtue of a TPO being issued. And so I believe that Representative Gaines has made several edits to his substitute that he's given us that is consistent with some of the requests that Chairman Setzler had asked about. But there is one issue that we need to discuss. And frankly, we can discuss any issue that the committee wants to discuss with this. But just to try to point things along, if everybody can turn to line 50 in section 3. So the context of this is the analysis and the findings that a judge would have to go through and would have to issue written findings in order to determine that that a family violence TPO could be issued under the context of a dating relationship. Is number one, going to line 48, there is a social interpersonal bonding of parties over and above that of a mere friendship or ordinary fraternization. And then number 2, factors exist which indicate that the nature and frequency of the parties' interactions are reflective of a dating relationship, including but not limited to the length and pattern of the relationship between the parties, or the parties having demonstrated an affirmation of a dating relationship before others by statement or conduct. So the real question here, and this is worthy of discussion. Again, we do good by talking things into the ground like this. And one of the things that we discussed last time is, this concept of online relationships. There are online relationships. There are people that are dating online that may not have met each other in person, but that is a status that people have in our culture and society, that they have an online relationship. And the question for this committee is, does the way that, but the language of number 2, does it make online relationships subject to this? And then the second question is, do we want virtual or online relationships to be subject to this? And Chairman Setzler had requested that we insert the word on line 50, that in-person interactions. So factors exist which would indicate the nature and frequency of the parties' in-person interactions are reflective of a dating relationship. And so his concern, thoughts with this policy is to exclude the concept of allowing a judge to be able to enter a family violence TPO against a person who has only been in an online relationship. And what this really does, not clarifying this, the question is does this bring into the concept of cyberbullying? And look, everybody in this room is on the same page, in that we all agree that cyberbullying is a horrible thing and needs to, it has been addressed and needs to continue to be addressed. But the question is do we want this TPO protection to potentially extend into, online relationships, or be applied potentially to cyberbullying relationships if cyberbullying, if it could be articulated there was some kind of relationship. So I present all that to the committee, and I want for Representative Gaines and Representative Wynn to tell me what your thoughts are. And if you think I'm wrong, and I also want the committee to do the same. And right now, number 8, is that Chairman Burchett? Okay, you're lighting up, so I'm going to call on Representative Saines.
To that point, and I know Chairman Setzler appreciates a contextual bill, but my understanding, and correct me if I'm wrong, if we leave that out, it would give the judge the interpretation of if whether it be included or not. Correct.
And that's what I want to resolve right now.
Okay.
I mean, that's
What?
And I think we do have a judge who was in the last hearing that on the line, Judge Manning, and,
Okay.
and I think she might be able to address this specific question.
And I would note, I get the cyberbullying element, but if this is trying to capture the relationship that would lead to someone feeling the level of making the other party discomfortable, serving on a school unit at a sheriff's department enlightened me to the various tools available to folks to frankly to put themselves in more danger of being a victim than anything that can be done in person. So I think as a policy stance, I would be more comfortable with giving the judge that discretion to analyze that relationship. And frankly, an online relationship pattern should be easier it's more documented. So I feel like excluding that excludes what could be more of a contextual case to get that information.
And let me interject this. I think that one of the things that I'm having to remind myself is that, like a lot of bills, you've got to read section 2 and 3 together in this bill. You can't read them on an island. You have to put them together. And I do know that family violence definition, as it stands in current law right now, if it's a felony or battery, simple assault, stalk. So there has to be some kind of either physical crime, or there are property crimes. Unlawful restraint that's a different concept than a physical crime or property crime, trespass, but so we've got these qualifiers. And I think the key through this is thinking through this. And I will say this, I wish I've had a busy week, so I haven't had the time to go through this like I prefer to, but I'll give the authored Representative Wynn the opportunity to kind of respond to some of the issues that I've put out there on this.
Sure, and thank you, Mr. Chair. And you brought up exactly what I was going to comment on, that this does not enable two people who are in an online relationship to file a TPO without the occurrences of the actual family violence. So there has to be the incident of battery, simply assault. So under the way in which it's written, I think the issue with putting in person, the frequency of the in-person party interactions, is that there are going to be some cases in which people meet online, their relationship develops online, and maybe they have only gone out on 1 or 2 dates, but during those 1 or 2 in-person dates, the family violence occurs. And so I don't think it's I don't think the question is online versus online, non-online dating. I think it's just the recognition that relationships can develop online first, and the frequency and nature of in-person may be a lot less in some cases versus the other. And Judge Manning actually shared with me an example which she'll talk about, but there is a case of a woman who appeared in her court twice who didn't qualify for a TPO because they did meet online, and then they went on 1 date, and during that date she was raped by the person she went on a date with.
Was the person charged with rape?
She probably on the criminal side, but she wasn't able to issue the civil TPO because this current law doesn't exist to extend to dating relationships. And then if we were to pass this with the in-person qualifier, she likely would be denied a TPO as well.
And I don't want to speak for Chairman Setzler. He's not here. I wish he was here, but I think that, part of what his concern is what we're doing in essence is we're extending the range of what the concept of family violence includes. And I think that that there is a uniformity in the comfort of family violence, including what we think of in traditional dating relationships. But then the question is does an online relationship where then there would have to be one incident, which could be as minor as a criminal trespass. So again, we've got to look at the words here, and we've got to look at every scenario. We've got an online relationship that could then result with something, the least, I'm not saying a trespass is insignificant. Trespasses are significant. In fact, you just heard me say that very strongly in the bill before. Trespasses are significant. But, we're talking about a trespass, that an online relationship in combination with a trespass, which very well, your property can be trespassed upon and you not even be there, right? And that results, that gets you to where we are with the issuing of this TPO. And the question that has to be asked is that the right policy? Is that what, issuing a TPO is a very significant thing, and it has a very significant impact on a person. They're not things to be taken lightly, is what I'm saying. It becomes a part of your GCIC and NCIC, I think in a lot of cases. And is an online relationship in conjunction with a criminal trespass that didn't even involve the victim's presence, is that what we want to get us there to this? And I'm free to, or you're free to talk, to talk freely about that.
Well, I think that the way in which the bill is written is in the circumstance that you're referring to. If there was a trespass and it was an online relationship, the judge would also take into account other things, right? And so it could be a situation where it was an online dating relationship and there were things that led up to the trespassing on somebody's property. And I would say that the trespassing on a property in conjunction with whatever other circumstances that led up to the trespassing would be a huge violation and a dangerous one as well. And so I think that the way in which the bill is written, it does allow for the judge's discretion to account for other things outside of just that one criminal trespass.
Right. And the context is important, but again, when we put this in play, we open the door for the scenario I'm describing to happen. And that's why we have to, that's why we have to talk through this. When I believe that the vast majority of judges have the wisdom and discernment and the good discretion to figure out when to and when not to award a TPO. But there have certainly been times in the legal history of our state where TPOs have been issued and they shouldn't have been. And, and frankly, it probably happens a lot more frequently than we wish that it did. Because we got imperfect system, imperfect people. They're presented with imperfect facts. They're presented with half the story, not the full story. It happens all the time. I've had clients that had a civilian warrant taken out against them because half the story was presented. And these things, and so when we open the door for this, we're opening the door for those type of results. And so I'm not trying to be argumentative. I'm trying to make sure that we really, really figure out what we're doing here and what potentially could happen. Because, I think that again, and I'm not speaking for Chairman Sessler. I'm, what number are you, Chairman Burchett? But I know that he, I think his concern is how far do we stretch the concept of family? And if it does embody online relationships, then, that's a lot more, it's a real thing, but it's a different thing than an in-person romantic relationship. I'm going to go to Chairman Burchett.
Thank you, Mr. Chairman. And I'm too just digging in on this, and I really want you to debate it and tell me I'm wrong. So I'm just going to give you a scenario. I've got an 11-year-old and he's text messaging. He's got a little girlfriend. All right. So if he's text messaging with his girlfriend, and this is in the educational setting, correct? It shows. and he and his buddies sneak out one night and they trespass and mom doesn't like it, then could this work under that scenario? Can he get a TPO under that scenario?
I don't believe so. So we were very careful to define the dating relationship, right? And we did take some of the recommendations that Chairman Setzler offered. So it has to be a romantic relationship characterized by a level of intimacy. And we added that is not associated with a mere friendship or between persons in ordinary business, social, or educational context. So in the instance of your son texting in an educational context with another student, that would exclude. And then we talked about this before. We
Mhm.
did not want to require the sexual involvement. And then again, there has to be the offense of what we define as family violence. And then the section 3 is where the judge's discretion comes in, right? So that is where it says it has to go beyond mere friendship or ordinary fraternization. So there has to be a proof that is an intimate dating relationship. And I think at the heart of what we're getting at is domestic violence, the way in which it works, that intimate relationship, whether through two people who are dating, two people who are married, or family members, it's very cyclical in nature, and it has a lot of issues that are intertwined with the closeness of people and the cycles of how things work in DV. And so under the current stalking code, you have to show all these patterns of behaviors, right? So if somebody is in a situation where they are dating and there's an instance of violence one time, right? They're not able to get a temporary civil protective order. But what we know to be true in intimate partner violence is it's usually not one time. And so we're asking victims for multiple instances in order to get a stalking order. But we know in some cases, they don't get the chance for those multiple things to occur. And we don't really want to put a victim in a situation where it has to escalate up to a certain point before they get any kind of civil protective order. And then in the case that you mentioned, the judge would be looking at all of this evidence and be able to discern. I think Judge Manning could perhaps weigh in on
Sure,
this.
and I think it might be the right time to have her testimony. Judge, can you hear us, and can you speak so we can see if we can hear you?
Sure. I'm not.
And Judge, thank you, and we all appreciate what you do, and I'm anxious to get your input on kind of what we're discussing specifically. I know it seems like we're probably beating the horse here on this, but you know, I also think that you understand why we're doing what we're doing. So
Absolutely. Any of you are free to tune in Monday through Friday to my YouTube channel and see exactly what I do and see what I deal with. So first, let me address one of the chairmen said juvenile. If juvenile comes in, they can't take one out. I send them to juvenile court. Those are addressed in juvenile court because the juvenile's name can't be put on GCIC. It would be their parents. And there's then there's TPOs against one parent against another. So those are sent down to juvenile court and they're handled in juvenile court anyway. Number one. Number two, let's see, what else you said? You said text messages. So if people are bothering each other with text messages, juveniles or either one, if you can see some of the text messages that I've gotten, so they're met each other on a dating site. The one example that she brought up, I've had somebody when you said, was he charged with rape? No, he wasn't. Not then, not when she came to me. He wasn't. So what do we do? Do we put a temporary protective order in place and protect this lady for now? We're back on track, so we're not having to wait because I caught those 1,000 cases up. So do we wait 15 days and have a hearing? And the guy may get served on the 14th day, so it's in place on the 14th day, and we have a hearing, and I'll listen to all the evidence. Or do we not protect this lady and wait 6, 8, 10, 12 months until we get the DNA or till the cops think they have enough to charge this man with rape? If or do they wait enough to say it's not? And in some of mine, when they come up, and if I do a TPO hearing, and I'm like, if the cops find this unfounded, then, sir, you can put this back on the calendar and I'll dismiss this. Because sometimes I don't have the DNA and I have people and I have to judge their credibility. And sometimes it's very, very hard. And if you've got to have some proof. Now, some of this stuff that's going online, they do mate and they do rape somebody. Now, criminal trespassing when somebody's not there, they're not going to have evidence of criminal trespassing. But if they do meet online, some of these relationships get really scary. Some of them do things that obviously none of us would do and don't do, hopefully. But the first thing they start doing is sharing nude pictures with each other. And I'm not talking, just classy nude for whatever that is. They're sending pictures that are, I've seen things I cannot unsee.
You know it when you see it, right?
Yeah, I've definitely seen things I cannot unsee. But then they start doing that. And then they're not like the little kids that are sharing pictures of one another. Like his 11-year-old who'll be later, and this girl sends the pictures of her boobs, and then he shows it with all his friends. They're posting this stuff on different sites and Instagram and whatever all those things are. They're posting it on that. And then these other people are posting it. They're posting on these websites, and they're posting on these porn sites. Pornhub, I think, is one that they do. And they put up these sites and this lady's phone number. So then it's doing all of that. And then they go to meet her, then they're harassing her. Well, then maybe there's a drone out there where she sees later that it's on this site. There's pictures of her houses because she learns. So, is that family violence? Yeah. Is it stalking? Well, she doesn't find out about it till later. But if somebody shows it to her and he's doing this, can she get a family violence thing? Maybe. Then he starts threatening her. Well, there's some family violence. So in the one time that he's met her, maybe he starts threatening her. If you don't do this, I'm going to kill you. Well, is it not stalking? But if you don't send me this, I'm going to kill you. There's so many things that happen online that may not lead to stalking, but it is family violence, the threats, the assault, the simple assault. I'm going to kill you. And these people are really worried about it. Now, I think some of the problem here is that we really have to educate some of these judges. A lot of these judges need to be educated on what it is. And it's fairly simple. You're right. It's to get an ex parte. But I reject so many of my ex partes because they'll say, he harasses me or she harasses me 30 times a day. Well, what does that mean? What does they harass you mean? If they're calling you because you're not giving the child over on visitation days and you're breaking the visitation, that's not harassment. That's a reasonable rate. That's a reasonable way. He's got visitation. You're not giving it over. That's a legitimate contact. Denied. Denied, denied, denied. I ask questions. I had a lady who applied for a stalking order. This is when you say stalking can do too. When she came in front of me, the guy had, I think I told you about this last time, rented a website. He did this website. The lady had a PhD and she, his girlfriend or something left there. Well, the guy got really mad. Don't know why. He posted all this stuff on websites, made her name. She got fired. She's reduced it. She had her PhD, ruined her career, ruined her professional career. She couldn't prove that it was him that made the website. She couldn't give me an IP address. She couldn't do that. She went all kinds of people trying to do it. Finally, she happened to connect with, because somebody brought up cyberbullying, with an FBI agent who just happened to take it up the channels, and the guy went up and finally helped him charge him because it went across state lines and over the internet federally. One case. But this lady suffered for 2.5 years and lost her career. So no, there's not really anything in the statute that covers cyberbullying under stalking either. So we got a lot of holes to plug, but I'm really concerned about nobody. If there's a judge out there, Mr. Chairman, I think it was you or another one that brought up because your neighbor gets mad at you because you borrow his lawnmower too much, then they don't need to be on the bench. If they're signing ex partes because your neighbor gets a family violence TPO or a stalking order on you and just makes it up and they believe that, they really don't need to be here in these cases.
And I think you raise a great point there, but I think, certainly I've been practicing law for 16 years now, which is frankly not a long time compared to many other people in our profession, but you do this long enough, especially if you do domestic work, and I do a little domestic work, and the circumstances that are presented oftentimes on these are nothing like what we contemplate in this room. And you kind of hit on it with when you've got custody situations and how ex-spouses will abuse other aspects of law because of an underlying custody situation, and it's maddening. And I think that most judges do the absolute best job they can, but but there are definitely cases where they get it wrong, and I think that our job, and the reason why we, on these kind of particular issues, we dive so deep into this is because we want to at least be able to say that we did everything we can to make clear. I think what you said a second ago regarding educating judges, enough can't be said about that in some circumstances. But let me ask you this, Judge. Well, actually, Chairman Burchett has a question for you, so I'm going to pass it to him.
Thank you, Judge Manning. I appreciate you coming and testifying. And I just want to dig with you a little bit further into the narrative I gave earlier. So if my son's not 11 and he's 17, and he and his girlfriend are holding hands, which that seems to meet the social interpersonal bonding of parties over and above the mere friendship. I don't generally hold hands with my friendship, so it meets that element. And then the factors and they've acknowledged that they're dating via text or wherever. And then there is a criminal trespass, whether it be by his girlfriend or him. Then under this new dating relationship, then a TPO could be issued. Is that correct?
What's the criminal trespass?
Well, it's one commission of criminal trespass.
Oh, what's in their petition? What's the criminal trespass? Dad caught your son going over there, climbing into her window?
Sure.
Or leaving a present on the front door without permission to come on the property. I mean that if you don't have permission to come on a property,
I'm going to listen to that and say, no, denied.
Right. And we know that we understand how you analyze these. But again, we're trying to think through other analyzations.
It's like you can't, it's just like it. And it's just like you mentioned, any violent crime, people get charged with rape. And when I was a cop, because I was one for 15 years, I arrested several people for false report of a crime. Unfortunately, I did. But what was I supposed to do? I looked into what it is. I asked questions. I figured out that no, something's not making sense. Something's, it's not lining up. The judges have to explore. Just because they say, oh, he did a criminal trespass. Even on that, I'm like, what does this mean? I'll send the ex parte back. I said, no, I need more details. You can't just say he did a criminal trespass. What does that mean? Who said he did that? My dad. Whoop, no. I want to know what you think, not your dad. Not your dad. Not your dad. So, I asked the questions at the ex parte, and that's what people need to do. You've got to trust your judges. I don't think this is going to create any more issues with ex partes or 12 months. I don't think you're going to have a flood of these. I really don't.
Thank you, Judge.
Representative Lopez.
Had a comment on that section that we're discussing, section 3. I do believe that adding the in-person just negates the fact that these relationships can develop online, and we have kind of moved away from that discussion. And I know where you're coming from, and I know it will give you more level of comfort of strengthening those factors that a judge will have to consider without adding that in person.
Let me ask y'all this, and Judge, this is directed at you more than anyone. If in line 50, are you looking at the bill?
Yes, sir.
In line 50, if it read factors exist which indicate the nature and frequency of the parties' interactions, comma, in person or otherwise, comma, are reflective of a dating relationship, ... If it was added in person or otherwise, that it kind of, what are your thoughts on that? And I think the value in it is that it allows analysis of online matters. It doesn't cut that out, but it also emphasizes a difference between, a different level, not necessarily a different level analysis, but just a differentiation of in-person or otherwise. What are your thoughts on that?
So as long as it doesn't exclude it,
Is anyone, I know we're thinking out loud right now, but does anyone here believe that that would potentially exclude something other than in person? I'm going to go to Representative Sains right now.
It's irrelevant to the question you just imposed, so I can table my.
No.
other question.
I think we've moved on from that.
And Judge, thank you for your testimony. Back to what Chairman Burchett alluded to in terms of a son going over, and frankly, I've had a lot of angry fathers in terms of not personally dealing with, but in a professional context.
Careful what you say here. The man has rights.
But how many protection requests come from minors? If we were to add in the bill over 17, that this applies for parties, or at least one party being over 17, what damage in your perspective or the author's perspective would that do?
so if they're a juvenile, they do go to juvenile court. I mean, like I said, because they're even on behalf of the parents taking it out, it won't work because they're not juvenile or juvenile. The juveniles aren't protected. They have to go to juvenile court. But since there was no school pretty much for this year and most of last year, so on a year when they're in-person school, there may be 4, and it's mostly because of bullying at school. It's in-school bullying.
So, and I would allude to that there would be other protections if we, in looking at not scoping it in for physical, if that is a concern, I would be more ready to do this for, party, adding the restriction of a party being over 17 versus adding the restriction of it having to be in person. Because I think the reality of today, in the context of the problem, that would be more of a use than others. And I have one more quick question.
Sure.
Sure. All the legal terminology in this, and this is particularly for the lead sponsor, Representative Gaines. Could you walk me through a more practical understanding of the circumstances that apply to the intimate dating term in your bill? Maybe a more personal understanding of that. An example that would capture an intimate dating relationship.
I mean, which lines specifically?
I think it's line 20.
Are you looking at 28?
28 and 29. What kind of characterization? I know you're kind of an expert in that area, so what characterization would you give? I'll hold my question to a more relevant time.
Thank you.
Okay, so here's what I'm going to do, and I know that there are some people that want to be heard, and this is what I'm going to tell everybody what my thoughts to do right now are. And if after hearing that, anybody still feels like they need to be heard, what I'd like to do is try to move on to the next bill as soon as possible. I am going to propose, if there is a motion and a second, I'm going to propose an amendment that would add in person or otherwise after the word interactions in between commas. And I'll propose that amendment, and I would be comfortable moving this bill forward under those circumstances. And what I would really love to do is to do that right now, unless anybody needs to be heard on anything else. Is there anybody online that needs to be heard, kind of understanding what it is that I am attempting to do right now? Representative Bodie do you have anything to add, kind of understanding where we are?
The only thing I wanted to add, Mr. Chair, I think Representative Lopez might have touched on this. I think we just need to trust the judge's discretion, and I think Judge Manning has done a great job of
You're
kind of
going above and beyond what I asked for.
I know.
Trying to move this along, trying to move this bill.
All right,
along.
okay, Mr. Chair, I'm good. I just
Okay.
want to get that
He
one
was trying to
comment.
give me a compliment. If I could just say this before I leave, if there is something where somebody wants to try to wiggle something about age, I think we ought to look at the age of the respondent. Because if you have a respondent that's above 17, that's mostly what I'm kind of worried about, because then a parent could do something on behalf of their child for a respondent. Those are typically, because you got a lot of older men liking these younger women or vice versa. So times have changed, ladies and gentlemen, since we were younger, a lot.
Except for Representative Gaines.
Sure, exactly. But thank you all for having me and let me speak. I do appreciate it. Thank you for all the work you do.
Thank you, Judge Manning. Thank you for what you do, and thank you for dealing with us through this. You've been extremely helpful, and we're very, very appreciative of your time and input on this. So is there a motion in a second? Oh, we've got to have a motion do pass on the bill, and then a second, and then I'll propose my amendment. So, all right, there's
I
a
have a
motion. Is there a
motion.
second?
Second.
Okay, so there's a motion second. Are there any amendments? So I am going to propose at the end of line 50, after interactions, be a comma, and then insert in person or otherwise, comma, and then it would read on as 51 goes. Is there any discussion on my amendment? Seeing none, all those in favor of the Reeves amendment vote by saying aye. Any opposed? Okay, the ayes have it. The amendment passes, and so now thank you. Thank you, Gravely. Now we are back to the underlying bill. All those in favor of the passage of LC 412967S as amended, vote by saying aye.
Aye.
Any opposed? Okay, the ayes have it. So your bill now moves on to full committee.
Thank you, Mr. Chairman.
Thank you, Mr.
Thank y'all for your patience in working with us on this. Okay, so if I can get Mom to hand, do you want to stay where you're at, or do you want to come down here to the? Why don't you go out and get Mr. Busey and. Okay, so that everybody knows what we're going to do with House Bill 327 is I'm going to allow Representative Momtahan to walk through the bill, and he's going to give us an explanation, and he will have Thomas Busey from the Retailers Association that will be here assisting him in that, and we can ask questions. And then I believe there are multiple people that have asked to speak both in favor of the bill and some opposed to certain parts of the bill. And so we are going to, my goal is to hash out as much testimony as we can so that this committee will have had the chance to hear what there is, what the debate is on this bill. So Mr. Busey, if you want to have a seat, and your microphone is on, and Representative Momtahan, you're number one, right?
Let's see, I've got that here. Yes, that's right.
Okay, so, and we're working off LC 280056. Is that correct? No, that's
No,
not
sir.
the right
That's
bill.
right. That's incorrect.
Do
We
we-
have, let's see. We
So
have a
it's
sub.
217S, is that right?
That's right. This
Does
is
everybody
the-
have 217S? Okay, I have one more copy right here. Chairman Burchett, do you have 217, LC 217S? All right, do we have any more of 217S's laying around? Okay. And then do our Representative Bodie and Representative Gravely online, do y'all have copies of LC 0217S?
They were sent via email.
So yeah, if you have it, it will be via email, obviously.
Thank you, Mr. Chairman. We do.
Okay, perfect.
I have,
So
Mr. Chair.
Representative Lopez, do you have which for House Bill 327, do you have LC 280217S? Okay, perfect. All right, so it sounds like everybody has the correct bill. All right, well then Representative Momtahan, the floor is yours. Your mic is on and Mr. Busey's mic is on.
Thank you, Mr. Chairman. Again, this is the substitute to House Bill 327, LC 280217S. So this is a bill that, for the most part, came through last year. It was passed out of the House. And we'll go ahead and take you through a 30,000 foot view. And then, unfortunately, with a lot of these bills, I usually say I like to explain a bill in less than, let's say, 3 to 5 minutes. This is not one of those bills. There's just no way to do it. It's a very large, complex piece of legislation that has many moving parts. And so, if y'all will bear with us as we go through the explanation of the bill. Okay, so this is the Organized Retail Crime Prevention Act. Let's talk about what the purpose of this bill is. The purpose of the bill is to prevent organized retail crime by requiring record keeping for the sale and purchase of stored value cards and the sale of goods by third-party sellers on online marketplaces, and implements criminal penalties for retail crimes. As we go through the bill, we'll take you section by section. Part one, obviously, is just to name this act. As we start into part two on line 23, this is a section that deals with the recording of card transactions by unauthorized merchants on the secondary market. So this is the same language as we saw in the 2020 version of House Bill 488. This closes a loophole by requiring any unauthorized brick and mortar merchant to the same standard to which we hold pawn shops purchasing store gift card.
Representative Monahan, if I may,
Sure.
in the substitute, there are some changes to definitions from the previous versions.
Okay, so let me go back and see here.
BC, do you want to point us to
If
the?
you want to point to that change, I'm
I
sorry.
absolutely will. We had two definitions of the actors that were taking place in this practice, and in the substitute, we changed those definitions to further specify what we're after to make it less ambiguous. We think that that's important.
Can you tell us where?
Yes, beginning on lines, and I'm working on the substitute from my phone. Line 24 and page 2 and page 3 are where the changes will be. We had previously just the definition of a corporate authorized seller and a corporate issuer. To walk you through the actors in this and how these definitions work, the corporate issuer is going to be the company who issues the gift card initially, or the company where the gift card can be redeemed. It also includes its affiliates. So if you had a Gap gift card, you'd be able to you redeem it at all the affiliate merchants that are in that family. Thanks, sir. Old Navy, et cetera. So it's similar to what we had before. Then you have the definition of corporate issuer agent, which is new. That is third-party marketing companies that that work for and with retailers that can be the bridge between a corporate issuer and a corporate authorized reseller. A corporate authorized reseller would be the end company. If you think about seeing the gift cards on the end cap, that would be the corporate authorized reseller. We did not change anything in the definition of stored value cards. We created the definition of third-party card. A third-party card is a stored value card. When it is sold, it becomes a third-party card when it is sold to a third-party card dealer. So just to make that clear of what we're talking about, when that card moves into the hands of the third-party card dealer, it becomes a third-party card. And a third-party card dealer, whereas before, I'm sure you'll all remember, we had the term merchant. It's very broad. And so we defined that as a third-party card dealer to talk about who is actually purchasing these on the secondary market. The rest of the changes are just to align the language with the definition changes.
And let me interject here, and for context, to remind everybody in the committee and for the benefit of Representative Lopez, you keep hearing this. We have a lot of bills that didn't get finished last year, and they all coming back this year. And this bill logged more time in this committee last year than anything else by far in a long shot. And with that section, all of the sections except for part
3, section
3, part 3, which is lines 82 through 214. It's a large section of the bill, but all other parts of this bill were exhaustively dealt with last year. And what I would like to do for purposes of today
Sure.
is let's focus on the new section, because
Okay,
I know that,
absolutely.
there's a sense of, I believe that we don't have debate or controversy over the part of this bill. At least we don't have new controversy. We have I'm
Yeah.
looking at our poet laureate, Representative McLaurin,
That's right. That's right.
and but I don't want to reinvent, or I don't want to bring up the controversy that we discussed from last year. We could do that in another time, but for purposes of today, since we have a lot of witnesses that are lined up and they are here specifically to talk about Section 3, let's just go through Section 3.
Absolutely, Mr. Chairman. Now, and I do want to just, if I can interject and say, if Representative Lopez has any questions, we are more than happy
That's
to
right.
answer them. So let's just say that, okay? I don't want to leave you out of the process. You're a great contributor to our committee, so we appreciate you.
Yes, Representative, that was.
That's
Yeah,
great.
yes, sir.
It's been fixed. Yes, thank you very much. Okay, so part 3 is the newest section of the bill. Effectively, if large quantities of merchandise from a retail store were reported stolen, you would most commonly find that in your local pawn shop. So if somebody went to a local brick and mortar and they took, size or whatever it may be from a local Home Depot or Walmart or Target, whatever it may be, a local brick and mortar store, that was going to wind up in a pawn shop.
You're talking about the theft of items then being resold in a pawn shop, right?
That's great.
Okay.
That was kind of the old age, right? That's where you're going to find these items, whether serialized or not. They were going to wind up there. What Section 3, and at that time, I will say that the state of Georgia kind of found it prudent to say, hey, you've got all this merchandise. We need to set some standard of record keeping, right? So they put some record keeping on the pawn shops and these third party kind of resellers, like pawn shops. And so what we're doing is taking that idea and we are bringing it into the 21st century. And so, and why are we doing that? Today, criminal networks are distributing their stolen products on sites like Amazon.com, right? If you ever go to Amazon, you're looking for a new bicycle, you might see under there that it says it may be lower, on a third party website. And so you can buy from a third party on the marketplace, that is Amazon.com. Now, if Amazon.com is not selling that product, you may see that it is only available from a third party seller, right? There are some of the folks that are stealing the goods that are then taking those goods and selling them on an online marketplace. And obviously that's problematic. So we see them on eBay, we see them on other online marketplaces where kind of these laxer rules permit them and the criminal elements to stay anonymous with no accountability. We feel that it is necessary and prudent for the state of Georgia to hold these modern actors to the same requirements as everyone else by simply accounting for and verifying very specific information. Aside from this information, assisting loss prevention professionals and law enforcement to help identify and pursue bad actors, this information will also aid consumers and give them the confidence that the items that they are purchasing are not stolen, counterfeit, or fraudulent. This language ensures that Georgians are truly getting what they pay for with their hard-earned money. It empowers consumers by providing recourse when they are victimized by these fraudsters. I'll give you a great example. If we owned a shopping mall, a strip mall, or a leased storefront in almost any Georgia community, you would be expected to know the identity of those folks that are conducting the commercial activity that they are facilitating. That's all this section really does. It just brings to light who's kind of behind the curtain selling these items on an online marketplace. And we're going to continue.
Yeah.
So Article 35. So let's open that up. That's going to be under part 3, line 86. It requires online marketplaces who operate in Georgia to record and verify certain information of high volume third-party sellers utilizing the online marketplace platform. This is very similar to the information from third-party sellers that these marketplaces are already using to collect and remit Georgia sales and use tax on their behalf. That information will include financial institution information, okay, contact information, business tax ID information, whether or not the seller is offering the merchandise exclusively on that platform or others. It's going to require the high volume third party seller to disclose to consumers their name, where they're located, an address, whether they are engaged in manufacturing, importing, or reselling, their contact information, and partial disclosure under certain other conditions. This also requires online marketplaces to gather and verify that same information Georgia asks upon shops when they buy and resell these goods. This requires online marketplaces to make conspicuously available to consumers a reporting mechanism where consumers can report suspicious activity. Hey, I received this. It was kind of damaged, so I don't believe it was new. It looked like maybe it was unsealed, or there was a tamper device that was still attached to the good that I purchased. These things could be obviously suspicious, but right now you wouldn't be able to kind of find out where those need to go back to, right? We don't know who these people are. Let's see. Requires the online marketplace to, I'm sorry, we just went over that. Let me get back to where I was. So requires the online marketplace to disclose to consumers the identity of any high volume third-party seller whose goods the online marketplace warehouses, distributes, or otherwise fulfills a customer order for. If you have anything you want to add to that, Thomas?
I do, Mr. Chairman, but one of our folks that is wanting to testify via Zoom has a hard stop at 2:30, and I'd like to, if we could, yeah, if we could have them.
2:30 Eastern time.
It is, unfortunately.
Okay, so it is. It's almost 2:30. So yes, we will do that. Who is it that
Mike comes with Home Depot.
all right, Mr. Combs with Home Depot. Are you with us?
I am, sir.
I apologize, and and please, I hope that you can go longer than 2:30 because it is 2:30 right now. But if I had known this, we would have taken you out in a different order. So please talk to us.
I made plans. I'm good to go.
Okay, great.
So good afternoon, Chairman Reeves and Vice Chair Gravely. Thanks for having us today. And thanks to the members of the committee. My name is Mike Combs. I'm the Director of Loss Prevention at the Home Depot. On behalf of over 29,000 associates at 115 facilities and a very proud Georgia-based company, I'm here today in support of HB 327, legislation addressing the serious issue of organized retail crime. I'm going to focus my testimony on Part 3, legislation that will close the loophole around anonymous sellers using online marketplaces to sell stolen and counterfeit products. But first, some background on the impact of ORC here in Georgia. ORC is a serious threat to the safety of our customers, our associates, and the Georgia consumers at large. And we certainly thank the committee for considering this issue. Organized retail crime is not petty shoplifting, but it's part of larger criminal networks who recruit individuals to steal with promises of big payouts on the other end. Ultimately, the leaders of these crime rings fly under the radar and evade prosecution because they conduct their misdeeds, both the theft of merchandise and the subsequent sale of merchandise, in multiple counties, across state lines, and even abroad. Organized retail crime takes advantage of some of the most vulnerable Georgians. This legislation closes loopholes and targets the most organized leaders and fencers of stolen and counterfeit goods. Particularly during this pandemic, the rise in e-commerce has led to more and more consumers buying online, which has given thieves more opportunities to defraud Georgians. HB 327 does not seek to tighten laws with respect to petty theft. Rather, this bill would allow better cooperation among law enforcement and our in-house investigators to get to the root cause of this insidious crime. The leaders of organized retail crime rings, their facilities and platforms that fence these stolen goods. Quite often, these stolen goods are aggregated and sold on unregulated online platforms. This avenue is the new pawn shop in Shorts, Georgia, of its true tax revenue. It also fails to provide basic retail protections for Georgians, things like guarantees of authenticity, integrity, or in some cases, the warranty or other safety measures. Consumers do not know if they are buying stolen goods from these nefarious actors until it is simply too late. This bill protects Georgia consumers and businesses. For consumers, it brings sellers out of the shadows, allowing customers to know who they're buying from. And for the businesses, it allows us to partner with law enforcement to track down the organized fencers of the stolen goods and who are taking advantage of the most vulnerable citizens. We ask the committee to consider supporting HB 327. I certainly be open for any questions you may have. Thank you again.
I'm gonna ask a question, and I'll probably have this question for other folks too. And I will tell you, as chair of this committee, I have a different strategy for different bills, and a lot of times coming into a hearing, my goal is to know the bill upside down, inside out, et cetera. With this, I've read the new Section 3, but I intentionally didn't do the deep dive that I normally do because I wanted to hear the testimony today from both sides, kind of understanding that we have a relatively large controversy here. I wanted to hear the testimony from both sides without forming strong beliefs of my own. And I think one of the things that I noticed that I think is a problem that I believe that the other side is going to raise, and it's probably a practical problem. And let me say this: you probably weren't online earlier. We were hearing the bill about porch pirating, but it's interesting how all these things are interwoven. And we've had two bills today that kind of deal with the same concept of this new and frankly raging industry of stealing online purchase merchandise or tools from Home Depot, et cetera. And I understand completely what we are trying to accomplish with that, but it's with everything else. It's how do we get there? And in line 90, the definition of high volume third-party seller. And I think that, the rub here is that we've got in line 92 to be qualified as a high volume third-party seller, you have to have a minimum of 200 or more discrete sales or transactions. And then it also has to have an aggregate total of $5,000 or more in revenue. And I think that, the concept of selling things online and from arts and crafts type stuff to whatnot has become such a large industry / hobby in some cases, just a part-time thing that is while that threshold very well may be crucial to helping you in the retail industry achieve what they're trying to achieve, that is a net that when we throw that out in the ocean, it brings in a lot of business entities that are very, very small, minor hobby type business entities. And as we go through this, that the requirements that this makes, it is substantial and a little overwhelming. I've never run an online business, so maybe it's simpler than I think, but gathering the information and reporting it, it very well could be something that could be overwhelming to a person that is running a very small hobby-esque business that that they do sell more than 200 and they do make more than $5,000. And I think that as we go through this, that to me is one of the really central issues of how we look at what is done here and how it impacts. I understand and I agree with the goal that you're with what you're trying to achieve. But the question is how do we do so? Do it in such a way that it doesn't become unduly burdensome for businesses that very well would be captured by this, but that don't need to be. And so I don't know if that's helpful, but I would love to hear your comments on that.
Well, I think we're simply going after people that are large sellers, not the part-time seller, and people that are doing it anonymously. So just requiring basic information at the onset would make a huge difference in this business. I mean, if you were to open up, like, I like golf. So if I were to open up a golf store, I would certainly have to do a few things, a brick and mortar store, to open that up and do it legally. We're just asking for some basic upfront information on people so they can't hide behind the internet and sell stolen product. And I don't think the part-time business person would have any problem complying with that.
Well, and maybe they wouldn't, but is it appropriate and necessary for us to require? You have certain corners of industries where the abuse, the theft, and the rings are taking place, and then you have a whole lot of large percentage of online business entities that are that don't stand to possibly be kind of absorbed into this crime ring that you see and that affects you and that costs you millions and millions and millions of dollars. And so, how do we divide this up? How do we divide this up so that our small, art businesses that are run out of living rooms, aren't required to do this, to do the same things that the folks that we're trying, and it might be impossible to do that. Maybe it's not possible, but I think that's going to be the primary issue that the committee is going to have to look at on this. Mr. Busey, do you?
If I may add and attempt to answer the question, Mr. Chairman, it's an important consideration here that in the lines that you mentioned, line 92, that we're talking about new and unused merchandise. So if you are selling 200 of a used item, this does not comport to capture you. To the requirements, which I would add that the requirements here of the information we're asking, I consider to be reasonable. But to your point of the thresholds, it's 200 transactions and $5,000 of new and unused merchandise. Now, I believe in a conversation that I had earlier today with Representative McLaurin, I think a way we may be able to address that is looking at the definition of consumer product. I understand your concerns on the Etsy and art and hobbyist activities.
Because those would technically be, if they were created by a person, they would be new and unused.
The question then becomes of how do you parse that out? Because the purpose of Section 3 is to not only have recourse on stolen items, but also fraudulent and counterfeit items.
Let me, I'm just thinking out loud right now. With the concept of new and unused items, what keeps somebody from opening the box of a weed eater and going out in their yard and using it one time and then selling it as almost new? And yeah, maybe there's a cut in the premium on that sale, but what stops somebody from selling it's almost new, it was used one time?
Too much work, and there's a significant cut in the premium of someone buying a used weed eater versus a new in the box weed eater. And a lot of times the reason that it is new merchandise is in retail theft. And to use the weed eater example, we will see listings on online marketplaces that have proprietary products. So it may be a line of makeup that can only be available at Walgreens. It's new in the box. How did it get there? It may be a weed eater that only is available at Home Depot. It's new and in the box. How did it get there? It's significant less. So I understand what you're saying. I don't think nothing that we could legislate would prevent that. The fact of the matter is that I think the premium is so that it wouldn't be in that case.
And Mr. Combs, tell me, do you have anything else that you want to say? And then I'm going to see if there's anybody on the committee that has questions, but just from a broader perspective, is there anything else you want to add to this right now?
No, I think I've covered it all. I think the people we're obviously going after are making a living on this. They're aggregating enough stolen product to really be high online sellers. And those are the groups we're going after, not the petty thief. And,
and this isn't a secret, and I'm going to say this to everybody. Obviously, we're not going to resolve this bill today. This is in my mind, the underlying bill from last year is mostly resolved, but this piece is not resolved, and we're not going to resolve it today. And that this is going to begin the conversation on that. And, I want for everybody that's involved in this from both sides of it to maintain an open mind in helping us as we work through this, decide what it is that we need to do. And if this is something that's ready to move this year, or if it's not something that's ready to move this year. I mean, we've got big issues to work through. And once we get through all the testimony, we'll have an idea of that. But, I would ask, thank you for being here, Mr. Combs. But Representative Lopez, did you have a question for Mr. Combs? Okay. Does anybody have a question for Mr. Combs? Because I think he has to be somewhere else. So does anybody online have a question for Mr. Combs? Okay. Thank you, Mr. Combs. And I have no doubt that we will be in touch on this and look forward to working with you on this issue.
Thank you.
Okay. Representative Lopez.
I just have one other comment on the 24-hour threshold. That's a little bit down on that same page. That's the one that concerned me. And so because not everyone that is selling is going to be doing anything illegal. And so I'm thinking about the small business owner that, is doing this and is growing their business. And that as soon as they meet that threshold, they only have 24 hours to comply with all of the requirements. I thought that was pretty cumbersome on someone. That was my comment.
And we are open to discussion on that 24 hours, Representative. I understand your concerns. Mr. Chairman, before I have the opportunity to speak to the bill specifically, I think just to highlight the issue, I think our other speaker with the Toy Association, it would probably be beneficial for the committee to hear from her.
Great. And we'll go ahead and do that. And so Mindy Baker with the Toy Association, can you hear me and can you talk to see if we can hear you?
I'm here and yes, absolutely.
Okay, great. We can hear you. So why don't you go ahead and tell us what you have to tell us and we'll see what questions we have.
Great. Well, thank you all for letting me be here today in this way. I'm Mindy Baker. I'm with the Toy Association. Not sure if you can see me, but you can probably, if you can tell from my office that I'm with the Toy Association. Just a little bit about our association. The Toy Association has been around since 1916. So we've been around for over 100 years. We have over 1,000 members. I always joke, if you can name more than 3, I'll buy you a drink at the bar later. Because over 1,000 of our members, you can usually only get 3 or 4 before you start to lose track. Most folks think of the big guys, but they don't think of the little guys. So we are predominantly in the US, about 95% small business. In Georgia, that number is 97%. So when you think of our industry, we actually are made up of small retailers, small manufacturers. We're the small guys. They have a couple of ideas and they want to bring it to market. I joke that even though we're a small industry, we have a big impact. There's about $2.3 billion economic impact in Georgia last year, and we contribute.
And that's in small toy stores.
In the industry in general. So
the toy industry in general.
Yeah, I mean, you got to think about it. Even in the most rural area, you're going to find a toy in a grocery store, in a feed store. Mm-hmm. Toys are pretty much everywhere these days. And so the distribution, the manufacturing, the warehousing, et cetera, the toy industry kind of encompasses everything. We have about, between direct and indirect jobs in Georgia alone, it's just under 17,000 jobs. It's just last year. So that being said, our interest in this bill specifically relates again to that Section 3, as you mentioned, but our issue is less about stolen goods and more about counterfeit goods. And we see this as a significant issue of consumer safety, specifically the safety of our children. We have documented cases of children being harmed, and in some cases seriously harmed and hospitalized because they got counterfeit toys online that then broke and caused that child significant hurt. This is not just a one-off. This happens on a relatively regular basis. By law, all toys sold in the US have to be compliant with mandatory product safety requirements. They have to be tested by accredited third-party independent facilities, and they have to have children's product certification. That isn't a requirement for counterfeit toys don't have those requirements, or certainly don't have that. They skirt that law. Legitimate toy companies spend significant resources to bring these products to market. Suffice to say, counterfeit toys don't do this, and our kids get hurt. under the current third-party marketplace system, illicit sellers with little or no accountability take advantage of the consumer faith in
Where,
online
where do they
marketplaces.
where do the counterfeit toys come from? I mean, where's the market for producing those counterfeit toys? And when you get it in the mail, do you immediately realize this is not what I mean, talk us through that.
So it's interesting. It's not always overseas, but certainly that is a big producer of counterfeit product. Unfortunately, I don't have them with me right now, but I could, if I were there, I could show you. I could certainly send it to you. One of the products that is often counterfeit or whatever, if you can see me, it's these things right here.
Magnetiles.
Oh, mag formers. Good
we have
job.
lots of those at my house.
So you want to make sure that you get the right ones. So mag formers, this is the legitimate product. And if I was with you and if you have the right ones in your house, I can sit here and I will try and break them, and I can't. I can send you online test buys that my companies have done, and they get the product and you can see side-by-side comparisons where it looks just like this. You get the box and it's literally word for word. The inside of the box looks the same. They have copy or counterfeit, even the little building instructions look identical. The product looks almost the same, but you can literally snap it in two. And there's tiny little magnets in here that can do real harm to a child and have done real harm to children. When you go online to sell, oftentimes right now on many online marketplaces, and because there is no regulation requiring this, any new marketplace that comes on board. So right now, I can create an online marketplace. There's no requirement. I can just say I'm Mindy at A1 Toys and start selling product. And if that's counterfeit product, that's counterfeit product. There's no requirement that these online marketplaces know who I am.
And so when somebody buys these products from Mindy's A1 Toys and they're obviously not legitimate or they're counterfeit,
right?
What is their, other than emailing the person, or what's their recourse right now? And I mean, I know on eBay there's all kinds of things you can do, like you could give somebody a bad rating, and when those things are, I understand that those things, that's a very highly protected and coveted aspect of selling on eBay. If you get a lot of bad reviews and people just skip you, but what are kind of walk us through what are the recourses that are available now, and how pretend like I'm in kindergarten on this. How are people able to hide? How are people able to hide from
very easily? So what they'll do is, frankly, as a consumer, your recourse is usually with the marketplace. You can hopefully return the product, maybe not. But that information isn't necessarily transparent to the purchaser. And that's one of the things that this current section that we're talking about does require. It does require folks to reveal where the product, if it can be returned, where it can be returned to. And that's one of the things that when we educate consumers, we actually have little one-pagers that we give out that we have available on our website, and we offer to anybody to talk about how to buy online safely. These are the things we tell folks to look for, which is where do you return stuff to? If I'm an unscrupulous seller and I get caught, most parents only look for, not just parents, cheaper, fastest returns. And the cheaper and faster delivery tends to be products that haven't been safety tested, right? Because that gets done faster. But then I get caught, right? That Mindy's A1 Toys, I sent out that counterfeit product, and you're right, they kicked me off the site. But I just have to sign up again tomorrow, and now
under A2, Mindy's A2 Toys, right?
Correct. And now there's no verification because they haven't they haven't verified that my bank account is the same, that my address is the same, that my phone number is the same. Whereas this information we're asking the online marketplace to verify is that would connect, these are the same people, or then allow that information to be stored so that law enforcement can say, oh, wait, we actually have some information. This is no more information than these, to your earlier question about, this information being cumbersome to a business. The information that we're asking for is simply address, phone number, bank account information. These are very simple things. These are not, we're not asking for tax returns. We're not asking for point of sale information. We're asking for if they wanted to sell at a local corner store or at a small mom and pop retailer in their community, they would actually be required to provide a lot more information. So these are, small, a little bit of information in order to, we think, curb a big problem.
Tell me this, what is the reality of, somebody's got a lot of counterfeit product. They open up shop and they have sophisticated ways of doing that and doing it quickly. And they sell under this and they move their product for a week, and then the complaints start to come in, and then they shut that down. And then in their sophisticated way, they're able to mobilize and then immediately do it under a different, and it just, the whole key to their business is that they just keep changing the website or the name of whatever it may be. I mean, tell me the extent of what kind of problem is that?
Well, I mean, so in January of 2018, the Government Accountability Office did a test buy of 47 consumer products, not just toys, but just general consumer products. And they found that 20 of those 47 were counterfeit. So, this is not just a toy product problem. This is a legitimate product, a big consumer product problem. I had a colleague here at the Toy Association whose home burned down because they think that he got a bad charger that he purchased online. I have a friend who owns a small business. He makes board games, and he's been making board games for 6 years. The pandemic's been really hard on him, and he had to take a second job during the pandemic because he primarily sold to small businesses and at conventions, which are all got shut down during the pandemic. And he found out last month that his product was being counterfeit online. So, that's the other thing too. There's no way for these businesses, small businesses, to proactively scour the internet to find out where their products are being counterfeit. So it's very difficult. All of the stuff we're talking about is also after the fact. These products are out there, and we're just simply trying to kind of put our finger in the dam right now. And the unfortunate part is, while we're doing that, kids are getting hurt. I mean, we have seen kids really hurt. We've seen people's homes burn down, and we're seeing people's businesses suffer. So it's really scary.
So how does this, and again, I'll speak for myself, but probably a lot of us, this is a new concept to the folks on the committee, probably for the most part. None of us have spent a tremendous amount of time thinking about this, other than the fact that we've probably all gotten something bad in the mail. I mean, I've experienced that as well. How does, so again, talk to us like we're in kindergarten.
Yep.
How does this bill, I mean, we've gone through, this is there's 8 or 9 pages of this new section of this bill. We've gone through a small section of it, basically the definitions, but how does this bill on a 30,000 foot level, tell us what this does to address the problem that you see?
So as a consumer, go online, if I walk into a store, I know who I'm purchasing from. I know that product has been screened. I know that it's a legitimate product. If I go online, I don't necessarily, depending on the website, have the information about who I'm purchasing from. This bill asks and gives the consumer information in order to make better purchasing decisions. So when I go online, I can see that I'm ordering from Mindy Baker. I can see maybe where Mindy Baker is located from. I can see if Mindy Baker has a physical address where I can return this to. Oh, wait, Mindy Baker isn't located in Georgia. Mindy Baker is located overseas. I don't want to send this. If I get this product, I don't want to spend money to ship it back overseas if it's not legitimate. Oh, wait, Mindy Baker. One of the other things we haven't touched on is this bill asks that it be revealed whether or not the seller is the manufacturer, a distributor, a wholesaler, because that also shows where they might be getting their product. You asked, for some sort of basic information. There's a term called commingling. I would ask you to just Google that. Certain online retailers will tell you they do not commingle anymore, that they used to, that they don't, or that they allow their sellers to make that decision. That some sellers do it, some sellers don't. Not every website does, but it does still happen. What that means is if you are in Georgia and you want to buy from somebody you think is in California, has legitimate product, but in order to get it to you faster, they will send you the product that is at a warehouse in Georgia that somebody else sent. And you might get a product that maybe the person who is in California that has legitimate product, that's not the actual product that they sent to that online platform. You get the product that was in the warehouse in Georgia, or in the warehouse in Georgia, every product gets stuck in the same barrel. So you get counterfeit product or stolen product mixed with legitimate product. And to use a medical term, there's no track and trace. It's very difficult to track down. So we actually have legitimate companies getting returned product to them, and they look at this product and say, this isn't the product that we sent to the company. This is actually counterfeit, or this is actually potentially stolen goods.
Let me ask you this. And, let's say that we pass this and this goes into law, and online companies choose to ignore it and not abide by it. I want to ask you about the enforcement of it. And I understand in lines 211 that it equates this to a violation of the Fair Business Practice Act in Georgia, which is something that as a litigator, I've litigated multiple cases and I'm extremely familiar with how that works in Georgia. It's quite a tool because it offers a plaintiff treble damages if they're successful. It's a very powerful tool, but it's also extremely complex. It's not a cupcake to put forward and prove a case under the Fair Business Practice Act. And, frankly, one of the greatest challenges of litigation of all of this is trying to figure out who these internet entities are. And I mean, it's very, very difficult. I depend on people like Representative McLaurin to tell me where to, where to find and who to sue and what state and what venue and et cetera, because he's very good at things like that. But this is is that the enforcement mechanism? Because it's a very cumbersome thing. And for a small, or actually not even for the business owner, for a consumer to hire a lawyer to pursue a remedy or to pursue being made whole under the Fair Business Practice Act, you're talking about spending a massive amount of money in litigation that is highly unlikely. It's very unlikely that, it's not that it's unlikely, but it's a heck of a hill to climb to get to that point. And it's one of those things where, like many things, it becomes cost prohibitive. And so while I understand, and I understand this very well, I think that it's a cost prohibitive aspect for consumers. But how do you enforce this? How do you deal with, other than a consumer who's been defrauded from this, pursuing a cause of action, which is extremely expensive? Short of that, how do you enforce people ignoring requirements like these?
I'll be honest. I mean, you're obviously more familiar with this particular section, the enforcement mechanism, than I am. I'm not an attorney, so I haven't had experience with the enforcement part of this. So I might defer to some of the other speakers to talk to that part of it. Because for us right now, we're looking really at this as an education piece for the consumer. And I think as a piece that, should the state's attorneys be interested in pursuing larger cases, the information is then available to them to go after this. I don't think that to your point, I don't anticipate, a consumer being, getting a product that breaks and then really going after somebody significantly. Now, again, if we had a situation in Georgia similar to some of these situations that we've seen in other states where a child is significantly harmed, then yes, I think there's a case to be made. And I think this gives us the ability to have that information at our hand. I don't think we're going to see every person who ever got, every person who ever gets a bad product. I ordered a video game for my brother this year and I somehow got a pencil case, so I don't think, that's not a case where I would then seek remedy. But I think that those cases that are egregious, where there is significant harm to a consumer, or in some of these cases where you've seen these large retail rings, because I think that is something else
Mhm.
that you alluded to earlier, where we've talked about retail crime rings, remembering that this threshold is low, but that is only this threshold is per website, and it is not a cumulative threshold. That this threshold is low, but it is also, there is no threshold to sell in a real brick and mortar. All of these things need to be verified. So I think this information is again intended for large scale cases. So
And I think that well, I certainly agree that the large scale cases in the rings, is where our efforts are best put. But then, as I was saying earlier, the problem is that unless we figure out a way to precisely kind of divide this up, we have the Etsy stores, having the same requirements, and the question is that what we want, or and at what point does it become overly burdensome? And I don't pretend to know the answers to the questions right now, but
Mr.
Chairman Burchett, yes,
Mr. Chairman, can I ask a quick
please.
question? Ms. Baker, one of the things that occurs to me is I'm not sure how far reaching this is. Do you anticipate that some of the folks that you represent will be caught up in this? They'll have to do the reporting like the rest of
Absolutely. And in fact, many cases they already are. So for instance, there's a company that I always joke you all know and love unless you've stepped on it in the middle of the night in your bare feet, and that's Lego. Lego actually owns a third-party platform for what they call adult friends of Lego, or adult fans of Lego, called I think it's Bricklink. And they actually it's an international marketplace, and they verify every online seller on their marketplace already, and they do far more than this actually already requires. So they're already owners of an online marketplace. They are already verifying all of their folks in a far more comprehensive way than this bill requires. There's many online many brick and mortar retailers that have online marketplaces that are already that are in support of this bill, that would be subject to it, and that are in support of it. Most of our manufacturers would be subject to the requirements of this bill and are fine with that. I think, they're looking at this as a way to protect their brands, but more importantly, we're looking at this as a way to protect the kids from bad product, because we don't want kids hurt. I think we had lots of conversations when this subject came up, which is, yeah, we can talk about it as a brand protection issue, but more importantly, it's a child safety and a consumer safety issue.
Thank you, Ms. Baker. Well, one follow-up, if you don't mind, Mr. Chairman. So, and I don't know the answer to this question. Do we contemplate to say that a large search engine, and notice now, if you make a search in a search engine, that it'll pop up for sale, whatever item that you're looking for. Do we contemplate to make one large search engine to say they're a third party now because there's a for sale? They're facilitating a for sale product at the top there.
Well, they would already be considered I think I understand what your question is. They would already be considered a third party marketplace. So depending on if they're selling the product or somebody else is selling the product. So that's another thing to remember, that we are talking about third party marketplaces, not marketplaces that are selling their own. So for instance, Hasbro or Lego. Lego has their own online store. Lego doesn't have to do it because they're selling their own product. Lego will do it for Bricklink, because that is where I would go to sell Lego product. In order to be verified to sell on Bricklink, I would have to be subject to it. So if I go online and type it in, if it's on that search engine, if that search engine has a marketplace, if that search engine's marketplace is selling it versus I'm selling it via that search engine's marketplace, that's the difference.
So the intention is not to capture the search engine, but
it's to capture the seller's information and show it to the consumer, so that the consumer can decide, I want to buy from this person and not that person, because this person's information I can see, or they can make an informed decision. I went online yesterday, and one of my members who is frequently knocked off and has had some bad things happen. His product is for 8 and up, and there's a product on there and it says 3 months. You would never give a product with a magnet to a 3-month-old, let alone a magnet that has not been tested and will spark when you put it together. But I could click through and I could see exactly who, because that particular online marketplace is actually already collecting this information. So I could click through and see who that was and say, oh, that's who that is. I don't need to buy from that person. And I could click through the other product and see that it was coming from the brand manufacturer and say, oh, I want to buy from them because they manufacture the product.
Sure,
That's what
sure.
this bill requires.
I think I understand now. I think maybe we may need to clean up the language, because as I read the definition of an online marketplace, it seems to me a large search engine that facilitates a sale, even if it's from the originating retailer, they're still facilitating the sale. So it may get captured in there is what I'm saying.
Mr. Chairman, I understand your question, and I think the question you're asking is, if you enter in socks into Yahoo and it shows you all the options of socks, and it doesn't matter where you go, that this would capture Yahoo. I don't believe that that's the case. What that does is aggregate results, then you choose where you want to go. So whether if you jump from Yahoo to Amazon to Jim Socks or what have you, the onus of the verification of this information would be on Jim Socks or any other marketplace. The search engine is just an aggregator. Now, if the search engine had its own marketplace, if Yahoo facilitated third-party sales, then the third-party seller there, that's when it would have to do that. But generally, no, to your question, which I think was more of a general, if I search this, will that capture? The answer is no.
Okay.
In my belief.
Okay, and Ms. Baker, I wanted to call you Mindy A1 Toys, but
Feel
Ms.
free.
Baker, do you have anything else, or Mr. Busey, do you have anything that you want Ms. Baker to testify about before we move on? And does anyone have any questions? Anybody online have any questions for Ms. Baker? Okay, thank you so much. And again, as you heard me say earlier, this is going to be an ongoing conversation, and your input was extremely helpful, I think, in helping us kind of understand what's going on here. And so we expect to be in touch with you
Absolutely
on this as well. So thank you so much. Mr. Busey, do you have anybody else?
No, sir, just myself.
Okay, so why don't you at this time, we've obviously kind of gone through, you know what we've gone through. So
Correct.
Why don't you fill in the blanks of what you want to let us know, and then we will and do it as in as
Absolutely.
efficient manner as possible, and then
Absolutely.
we'll move on to some of the other testimony.
Yes, sir. So it boils down to this, and this brass tacks is that this is just in this section is making sure that on online marketplaces, the folks are who they say that they are. And it does put that onus on that marketplace to verify. I think you'll be told that this is onerous, and it's not, quite frankly. The information that is required is very simple, and it is very basic, and it's easy to verify. Bank account information, I'm sure that you're going to get questions about security, and online marketplaces are going to go, well, how can we have that sensitive data? They have it already. Otherwise, these people that are the third-party vendors wouldn't get paid by them now. We're just asking that be verified. Business tax ID information, just to make sure that these people are who they say they are. And to Ms. Baker's point, they can't pop up multiple times. A contact address of where you're operating from, telephone number on how to contact you. The bill also contemplates that, well, what if it's a personal telephone number? There's exceptions made for that. What if it's a personal address? There's exceptions made for that. You're also probably going to hear, Mr. Chairman, it talks about parity of that. Well, this is brick and mortar doesn't have to do this. Well, I'd say that's apples and oranges. That if I'm, to Representative Montahan's point earlier, if I'm running a shopping mall and I'm facilitating 30 different third-party vendors to operate in the shopping mall that I own, well, I'm going to know their contact information. I'm going to know who they are. When law enforcement or a consumer has a complaint about business going on my premises, I'm going to know that because I physically know that because I can see them. obviously online marketplaces don't have that advantage, and to protect consumers, we feel that something like this is needed. I can't stress the point about counterfeit goods enough. In fact, earlier this year during COVID, and I forget which online marketplace, and I don't know if I would name it, but fraudulent PPE had become a huge problem.
Mhm.
I believe that there were a couple of $1 million worth of 3M masks that looked like 3M KN95 masks, felt like them, smelt like them, weren't them, and they weren't affected, and they were sold throughout, I believe, the northeastern United States. So it is a new way. I always bring you guys fresh, complicated, real simple ideas. I would like to thank you, Mr. Chairman, for your patience with us. I would like to thank you for having this hearing and allowing everyone to speak. I would say the most important takeaway from this section is it protects Georgia consumers by knowing from whom they're purchasing on an online marketplace and allowing them recourse. And it protects Georgia small businesses by allowing them to not compete with other people in person or online that are selling fraudulent, stolen, or counterfeit goods.
Okay, thank you, Mr. Busey, and we will, and obviously we will continue this discussion. I think what I'd like to do right now is have John Watson come in and testify. I believe that he is going to testify in person, and I believe that there are 2 individuals that are going to be testifying online. Can somebody see if John Watson is out there?
I believe I saw him.
So, Mr. Watson, thank you. What I'm going to do, we have heard from the retail side. I don't know how many people, who's still online with us?
I'm here, Mr. Chair.
Gravely and Bodie. Okay. We've lost a couple of folks, but we're going to keep going with this. Mr. Watson, what I'm going to do is I'm going to have you. So I have that David Edmondson and James Hines are testifying in a similar posture to your posture to the bill. Is that right?
They are, Mr. Chairman.
So what I want you to do is I want you to manage for me what you want to tell us and what you want us to hear from them. And so if you want them to talk now, or if you want to tee it up, I want you to kind of manage how we handle that.
If I could, I'd ask the association, the 2 heads of the association, to go first, and
Perfect.
And, they will be able to be more granular and slightly more detail, and I'll simply put a bow on it at its conclusion.
And just and who are you representing?
I'm sorry, Amazon.com.
Amazon. Okay. So I'm gonna is there a preference between Mr. Edmondson and Mr. Hines?
Flip of a coin, probably.
Okay, well, we'll start with Mr. Edmondson. Mr. Edmondson, are you with us? Are you? I think you're muted. And I understand that. I believe that you are in Texas, and I know that y'all have had power issues.
There we go, Mr. Chairman. Yes, sir.
Yes. Okay, great. Do
Yeah,
you
I'm
you have
going on
power
about a day
right
and
now?
a half with no power. No, I've got a cell phone with a battery.
Are you
That's all I've
cold?
got.
Are you cold right
I am,
now?
yeah, sitting in a 40-degree house, so I am cold.
Wow.
So
Well, this is
appreciate
riveting stuff, so
uh,
hopefully this warms your blood. But okay, so Mr. Edmondson, tell us who you're with, and I'll just let you kind of walk us through. Tell us who you're with, who you represent, and your position and concerns, et cetera, on the legislation.
Yes, sir. I appreciate the opportunity. So, Mr. Chairman, members, my name is David Edmondson. I'm TechNet's Vice President for State Policy and Government Relations.
What is TechNet?
TechNet's the national.
Okay.
Yeah, we are the national bipartisan network of technology CEOs and senior executives that promotes the growth of the innovation economy. So, in shorthand, we're a trade association that represents the broadest swath possible of the technology sector. I am here testifying in opposition to Section 3 of the bill. I'll say this language is unprecedented. The requirements don't exist in any state. It's injurious to Georgia's reputation as the #1 state to do business. I know my organization did submit a letter earlier this week detailing our concerns, but I can sum them up shortly. One, the bill would hamper marketplaces' technological ability to identify and remove illegal goods. It creates privacy risks for small businesses and individual sellers who sell online, and it does little to actually slow organized retail crime. But let me start by noting that it's in each marketplace's interest to maintain trust with the consumers using their platform. Otherwise, they lose customers. This is a serious issue. Selling illegal and counterfeit products is an serious issue, and that's exactly why marketplaces are heavily invested in both technology as well as personnel and processes that identify bad actors and remove them from their platforms. These tools are constantly being improved to ensure that they can accurately target bad actors. Unfortunately, passage of this law is very prescriptive. It's not future-proof. What it does is it locks in one stagnant approach that bad actors can adapt to, instead of allowing online marketplaces to innovate as technology adapts and as bad actors evolve. Second, the bill would force Georgians to compromise private personal information in order to continue selling on online platforms. It applies to individual Georgians who are selling their creations online merely because they average 4 sales a week. The open display of such personal information, which would be required of Georgians simply monetizing their hobbies, would lead to potentially dangerous situations. And those unwilling to divulge that information online would be forced to simply stop listing their products. Finally, the bill does little to slow organized retail crime, but much to place burdensome administrative requirements on online marketplaces that big box retailers would not have to abide by. In other words, it picks winners and losers by legislating a burden for small businesses that use online marketplaces. And this ultimately hurts Georgia businesses that sell on online marketplaces and Georgia consumers that want to have access to the broadest amount of goods. Law enforcement, local prosecutors already have investigative tools to pursue and arrest bad actors, and they work closely with online marketplaces as well as retailers to ensure that those folks are caught. But just as brick and mortar retailers are able to institute voluntary business practices that help remediate organized retail crime, marketplaces similarly should have the same flexibility to institute business practices without prescriptive regulation. Therefore, we must oppose Section 3 of the bill.
I have a couple of questions. I know you just mentioned it towards the end of your comments that law enforcement and prosecutors are actively engaged. You know, and just in fairness, part of my career, I was an assistant district attorney here in Georgia and spent 5 years as a prosecutor. And these, you know, cyber crimes, e-commerce based crimes, they require a level of sophistication of resources and law enforcement tools that, I'll just be honest with you, from my direct experience, we don't necessarily have in mass quantity. And so the way I see it from the seat that I sit in is that I don't think we are equipped, resources or perhaps even with our statutory structure, with the current ability to keep up with the level of fraud that's out there. And that's really, I mean, not really a question for you, but you know, just a clarification or a comment that I do think that we do have a genuine struggle in our law enforcement being able to, I mean, these are, you know, these it takes a level of sophisticated resources in order to be able to track this information down and you know, as always, as discussed earlier, venue is always the issue, and figuring out where venue is proper and making a case and bringing charges. And so those are challenges that I don't think that Georgia is sufficiently is equipped to deal with right now. And I'm not saying, and I'm not commenting one way or the other that this bill or that this proposal is the solution to that, but just in fairness, I do not think that that's an entirely accurate statement about, you know, our ability to pursue these crime rings with current law. And I think that what I would like to know from you, and I'm going to ask this from everyone, is there a way, you know, I think that from my perspective and looking at this, is there a way to work through this legislative proposal that can, I think we all can agree that there are bad players, that we need to be able to have better tools to be able to stop what they're doing. But that in doing this, perhaps this proposal, as I said earlier, it's a net that brings in way too many fish that we don't mean to bring in when we bring that net back in. And in your mind, is there a way to look? And I'm very interested in what you said, that this has not been, that this is not law, or this is not current in any other state. And that's something that interests me, and I want to talk more about that. But is there a way in your mind to take this concept and find a way to better direct or be more precise with what it's trying to do, as opposed to this broad net that we throw it in the ocean and it pulls in a lot of people that just that aren't our concern? Does that make sense?
It does. Yes, sir. Yes, sir. And I don't want to get too far out over my skis, just given that I have a lot of members that I represent, and want to make sure that before I, state something specifically with you on the record, that I have a chance to vet anything with them. But I know that they would value the opportunity.
We understand that completely, and we're not going to hold you to that.
Yep.
So.
I appreciate that. But I know that they would value the opportunity to be able to work through this process, to identify those specific concerns and make sure that, like you said, you're not including a grandma that is, creating hand-woven face masks and selling those online, and forcing her to, post her home address on the listings, because, to use your analogy, she would be caught in the net that this bill proposes. Sir, you make a very valid point that, the resources that law enforcement have, they're struggling to deal with a whole host of issues, and this is but one of them. I would say my point was mainly that, the online marketplaces do have dedicated teams of personnel that do work with the loss prevention leaders at retailers to ensure that, the technological tools that they're using, the investments that they're making, both in personnel and the ability to detect counterfeit and fraudulent goods and pull those down. Because at the end of the day, that does nothing to benefit the online marketplaces. It is in it's their desire to get them off their platforms as well, because they lose customers otherwise. And at the end of the day, that trust factor is so important, especially when Georgians have a lot of different marketplaces to be able to choose between.
Sure. And so let me say this, that I think it makes sense that you have online platforms and they, it's brought to their attention that somebody's selling and they're selling counterfeit or stolen stuff, then, then they're going to get rid of that person. My understanding, if I've misunderstood this, then I stand to be corrected on it. But my understanding with requiring this information to be available has as much to do with giving the consumer the ability to be able to actually track down the tortfeasor. I mean, I think that's the biggest problem, and we talked about it earlier. This is overwhelming. Somebody sells you something bad online, it's the juice isn't worth the squeeze to go after it. And I think that the way I understand it is it's more to benefit the consumer, so that the consumer actually has a more direct path to reach out to verifiable information, to reach out to that person, and also potentially be able to legitimately threaten legal action, because they actually know where they are, and they actually know where their business is registered, and they actually know these things and can verify them, as opposed to, dropping a hook into the Pacific Ocean and trying to see what you can pull out. What is your comments on that?
Sorry about that. I was on mute. I'll say most marketplaces, already provide useful information about third-party sellers on a product listing as a way to differentiate them from, other sellers of similar products. You often note when you go into online marketplaces that you search up a certain gizmo and there's going to be varieties of similar-looking products. And the marketplace, has most marketplaces, and I can't speak for every single one, but they provide a means to bring together those buyers and sellers, resolve issues, and intervene as necessary to work toward a resolution. It's in the marketplace's best interest to maintain trust and safety on their platform. Without it, you lose customers. But ironically, this legislation actually, encourages off-platform communication between a buyer and seller, which actually diminish that trust and safety that those online marketplaces are putting in place and investing resources into.
Does anybody else on the committee have any questions? Anybody online have any questions for Mr. Edmondson? Mr. Watson, is there anything else that you want Mr. Edmondson to, is there any other directions that you want to have him kind of go with us here?
No, sir.
Okay. So what I'm going to do is, and thank you, Mr. Edmondson, and I have a feeling that we'll be in touch with you again as well on this. We appreciate you hanging with us, and hopefully your cell phone's not about to run out of battery, and we really, truly hope that you guys get power restored and that everything is okay there. It sounds like y'all are about as equipped for winter inclement weather as we are here in Atlanta. It never seems to go well when it snows here, but thank you, and we will be in touch with you. And I now, if Mr. Hines, if you're online, can you unmute yourself and talk to us? Tell us who you're with and what they represent, etc. I think you're still muted, Mr. Hines. Do you want to see if you can get a message or call them? Just hang with us for 1 minute, everybody.
Sorry.
Again, Mr. Hines, if you were with us, if you can unmute yourself, it looks like
Sure,
you
Mr.
have.
Chairman.
Hey, you there?
I'm here.
Okay, great. Tell us who you are, who you represent, and then kind of walk us through your thoughts on the legislation.
Sure. Thank you, Mr. Chairman and members of the committee. I am James Hines, Director of the Southern Region for Internet Association. Internet Association is the voice of the internet economy. We have approximately 42 members who derive most of their revenue from internet platforms. I appreciate the opportunity today to address Part 3 of HB 327. We have submitted a committee letter that addresses our concerns regarding this. And because of the discussion today, I'm just going to briefly highlight 2 areas of concern, and then I would like to get to the question of how current marketplaces are addressing the problems that the bill attempts to fix, and what are some things that we can do in response to ORC. We've had discussion today about the potential effects on Georgia small businesses, micro businesses, and solo entrepreneurs. And I'll just state that we think that the verification mandates in Part 3 will harm businesses selling goods online. We think ultimately it forces online marketplaces to choose between increased liability exposure or removing listings of small businesses, micro businesses, and entrepreneurs. And this is a choice that is not made by big box retailers with in-person retail space. I'll quickly move on to a second concern, which relates to the compliance problems for marketplaces. Simply put, we find this bill to be unworkable with respect to capturing and verifying identification information and bank account information of high volume sellers. It's also unworkable with respect to increasing liability for privacy risk. When you read the bill, a marketplace would have to suspend a seller's account when they hit the $5,000 200 transaction threshold until the marketplace could confirm the contact information, the bank account information, and listing this personal contact information on each product listing. The collection and verification of this information is going to take longer than 24 hours. It could take a matter of days. In other words, marketplaces cannot simply flip a switch for their existing high volume sellers or for the sellers who will cross this high volume threshold. And we see this as a significant disruption to e-commerce business. And we think, yes, it will result in some loss of revenue for small businesses that are relying on this marketplaces. So to avoid this disruption, the marketplaces will have to capture and verify all sellers' contact and banking information in the marketplace. So that will be the practical effect of the bill. So those are our two major concerns, and we've detailed that in our letter. I want to move to the issue of what are our members doing today to address these problems, and what can be done in response to ORC. Many of our member companies are already combating illegal and suspicious activities in the marketplace. They have notice and takedown services for products. They have partnerships with law enforcement, federal, state, and local law enforcement with respect to investigations. Third, they have partnerships with rights holders, people who hold copyrights and patents on goods, to ensure that these goods are not on the marketplaces. And then lastly, they're engaging in proactive efforts to keep counterfeit goods off of their particular platforms. With respect to the question on ORC, I would like to change the discussion on that and ask states to begin thinking about a kind of a shared responsibility policy as far as working with online marketplaces and working with brick and mortar and big box retail stores. And one thing that we can do to address increasing ORC is, one, manufacturing traceability of products. So this is track and trace. This involves adding an identifier, adding a chip to a product that will help create a roadmap that can help improve loss prevention in brick and mortar stores. The second thing we do is recognize that there has been an increasing amount of retail employee theft that is a leading contributor to ORC. There are articles that we found state in which the National Retail Federation Vice President stated between an increase in incidents and new ways to steal, shrink is at an all-time high in brick and mortar stores. So by enhancing training of store managers for loss prevention, maybe we can help combat that. We acknowledge that ORC operations have become sophisticated in beating retail security measures. We just believe that, we can work to find new tech solutions to help combat this. One of those solutions may be coming up with dashboards with real-time loss data for certain products. Again, this would tie into track and trace products that you would have within the store. So we think that, there are some things that we can do. We don't think that we need to have part 3 to address some of these issues. The responsibility, our members again are engaged in a number of activities to make sure that products are taken down that should not be on the site. But I think having this shared responsibility discussion with retailers will help. Thank you for your time.
Let me ask you this. What is a couple of comments. Number one, I don't think anybody would disagree with you about the rise of employee theft, and that's certainly part of this ring. And my guess would be that any retail business that is being victimized by this is probably doing everything they can. And as far as realizing we've got holes in the ship and trying to, I would imagine that that's part of the puzzle that they're currently addressing. But as far as you talked about putting microchips on these things, is this, what's the cost, and I'm asking because I don't know, what's the cost of such, and how do, and if microchips are placed on products, what stops somebody from, whoever it is that has stolen them or whoever it is that is pushing the product online, what stops them from removing microchips, from identifying where they are and taking them off? What is the, kind of walk me through how that's a viable solution and what the costs are, if you know.
Yeah, we don't have specific details on the cost for chips. I think there are different tracing methods. It's not just solely chip. There are different identifiers that can be used. But yes, we could, come up with that information for you as to specifics on the cost, but we did not have that information today.
What you talked about it being, and I might have misunderstood the context. You talked about it being unworkable to identify bank information and verification information, but the way I understand it is that they obtain that information because that's how they use that information to to be paid. That I very well may have misunderstood the context of what you said was unworkable. Was what you said being able to identify the bank information, or were you talking about something else?
So as the bill currently reads, for a current high volume seller or a seller who's going to cross that threshold, you have to provide that bank account information to the marketplace, and that information has to be verified. So you have to capture two things. You capture the identification of the account and the verification of the account. And is my understanding from operations in the marketplaces that is not as simple as just turning over information that they currently have on hand, that there is a process for making sure that you have this correct information with respect to the bill.
One of the other things that you mentioned that I thought was actually an excellent point that I don't think we got an explanation from the other side. I don't know if the author of the bill knows the answer, but I think you alluded to something that talked about how would the marketplace track when a internet seller, I'm getting all the words wrong, this isn't my language. How would they track when a seller hits that 200 sales or $5,000 threshold? What's the accountability for tracking that? And I don't think that we had any testimony about that, but Representative Montahan, do you know the answer to that?
So that's for and just to restate the question. So you're asking what responsibility does the seller of the said good, so the third party or high volume seller, have to self-reporting that they've hit the 200 sales mark? Is that correct?
Well, I mean, isn't there some responsibility on the marketplace's end as far as, again, I may be completely misunderstanding this, but isn't there some responsibility in the marketplaces in, and how would they know that, let's talk about Mindy's A1 toys from earlier. How would they know that she's made 200 sales and that she's reached a $5,000 threshold? How would they know that? And what if Mindy chooses not to give that information? Mindy's A1 toys doesn't give them that information.
That's right. So I think in that case, for example, with Amazon or something like that, those numbers are already tracked. So they're given sales numbers, transaction numbers. They know what their gross sales are. They know the number of transactions that take place.
Okay.
And if I may proceed.
Please.
Yeah, what we're saying is the practical effect of the bill is that most marketplaces will have to collect all sellers' identification when they join the marketplace, because you do not want to suspend an account for a day, 2 days, possibly up to a week, with the collection and verification that they are a 200 transaction / $5,000 seller. So to avoid having that disruption, you'll have to collect this information up front. And so what that does is it increases your liability risk for privacy, because you're going to collect the information of your neighbor in Savannah who's selling a TV, as well as collecting information of a small business who has 500 transactions a year and $50,000 in revenue. And so that is, what is concerning to us is that, as a practical matter, we're just going to have to collect this information on everyone, because most marketplaces will not have the compliance personnel to be able to track transactions, up to 200,000, whether to cross 200,000, maybe even if they are already at the existing $200,000 threshold. So there's a huge compliance burden that makes it unworkable. So again, most marketplaces will just collect information up front.
Well, let me ask you this. I'm trying to think outside the box on this. One of the issues that we have is that the potentially unintended consequences of this is that it scoops up a lot of folks that don't have anything to do with the industries or products that are typically seen in these fraudulent type cases or stolen goods. Tell me why it would be untenable to say if you're in the online marketplace business of selling power tools or electronics or other things that we see a trend, that we see a trend in, these are the types of products that stolen products or counterfeit products typically are found. And that, so meaning it's highly unlikely that the Etsy mom or whatever would be producing something that would fall into that. What makes that approach, again, what I'm trying to figure out how to do is, if there's something that is worthy here and it protects consumers and we can move forward on something that's more direct and more precise, what would make it untenable to direct it to online platforms that are related, to these? If you sell power tools on your online platform, then you're required to do this. What would make that untenable?
I think what you can do is, as I stated before, our member companies have a number of techniques, a number of practices now with respect to partnerships with law enforcement, partnerships with right holders, notice and takedown services that we can currently, identify that particular activity. As far as obtaining information regarding suspicious activity, I have to note that Attorney General Carr and the Consumer Protection Division already have an app that's called See Something, Send Something, that allows Georgians to report suspicious or illegal activity. And so as I sit here to think that a consumer alert can be sent out, asking Georgians to report this sort of activity with respect to marketplaces. And this would actually replace one of the requirements of a bill for reporting this suspicious activity. So I think that there are mechanisms as far as working, with law enforcement, working with the Attorney General, and the reporting mechanism that they have already set up to capture some of this information. And I think also making these marketplaces aware, of these trends, they can tailor their current services, again, the notice takedown services, to proactive efforts to take certain goods off. They can tailor those services for those particular items.
Well, and I think that, being able to pass along information to identify, bad actors or, bad sellers on the internet is one thing, but I think that what this is geared at is giving the consumer, that is ultimately the victim at the end of this thing, a pathway to be able to actually trace it with more certainty, or really with just, more possibility, being able to trace back to have an opportunity to be made whole. And I think that that's something that's very different than, say, than the spirit of cooperation in law enforcement and all of those things. I think that what this is doing is trying to protect the consumer. And I'm not, I don't say any of that to try to make it sound like this is simple in any way, but I think that that's more of what this is directed to. I'm going to Representative Montana, your light's blinking.
Thank you, Mr. Chairman. And I want to kind of bring this fact up. I want to make sure that we're not framing the conversation in that these ideas are new, right? These are not new ideas. Back in 2001, I believe it was the Patriot Act that came out. And when they had that, they had a know your customer obligation for financial institutions. And so it just requires a, periodic update to know who you're working with, certain financial institution information, and what the businesses are doing and what they're selling, right? And so this is in the same vein, right? Mm-hmm. This is not the first time these kinds of regulations have ever popped up, and it is there to protect the consumer, right? Mm-hmm. So I want to mention that so we can frame that. These KYC obligations that they have are very similar. Just wanted to add that for context. Mm-hmm. That's
Representative Lopez.
Mr. Chairman, I just wanted to clarify, and I think that, Chairman, you alluded to this a little. So my question to you is, so this is cumbersome. Collecting this information is cumbersome when the small businesses that are selling their products meet the threshold, and therefore you will have to do that from, for all companies that are dealing in the market to avoid that disruption once that company reaches this threshold. And so I think earlier we were told that you collect some of this information already. And so my question to clarify is that you do not collect this information from anyone?
I think there is certain contact information that is collected when a seller signs up for a marketplace, and some of that information is already available to consumers that are using the marketplaces. What we are addressing here are the identification and verification mandates, which may ultimately result in some smaller players in the online marketplace. It may result in them just deciding not to have small business listings because it's too difficult to comply with the rules for obtaining and registering the seller information. That is one of our primary concerns regarding the bill.
Did you have any follow-up, Representative Lopez? Okay, so Mr. Watson, there's no other questions. Representative McLaurin, you have been eerily quiet, but I can tell you've been thinking over there. I can see that you've been thinking, but Mr. Watson, do you have anything else you want Mr. Hines to talk about, or anything that you want to go over with us?
Two quick things. I know the committee's been here a long time, and I will shut up very shortly. First of all, I want to say to Representative Monahan, thank you for bringing forward the issue. Obviously, it's important to be talking about fraudsters, criminality, and their impact on our businesses, whether that be a consumer or a business owner or otherwise. So thank you. Obviously, from an Amazon standpoint, 21,000 plus and growing in Georgia in terms of full-time and part-time employees, huge partnership in terms of what this state is to what we are as a business. Just wanted to comment very quickly about, from one platform, Amazon.com, the type of activities that we are undertaking. Last year, 2.5 million instances of potential fraud were rooted out when someone tried to do something wrong on our platform. And so in terms of being innovative, thoughtful, aggressive at making certain that we are getting after this, we do so and do so on a daily basis. Something like in a common sense solution, like making certain that there's a visual recognition in video to prove who you are when you want to come onto our platform. So again, everyone's been here a while. We stand at a strategic level aligned with Representative Montahan. Tactically on Section 3, we are not aligned, but nonetheless, the committee's been here a long time, and so thank you.
Well, and I know that this is kind of your quintessential example of where, I know that Amazon has invested tremendous amount of resources and into its interface, on the computer of making it easy to be able to return things, or if you've been, if you've gotten something that you weren't, they have made that easy. And so I think that I think perhaps a lot of what we see is it very well may be that we don't see as much of this type of stuff coming from Amazon. Amazon does things, on a very high level, and not every marketplace, or whatever the right word is, has, implements those kind of resources and those options, and the ability to make people whole, and so I think that this is one of those, quintessential examples where the people that do it right get categorized with the ones that don't do it quite as right. And I think, so I understand your position in that makes a lot of sense. And so, I think everybody understands there's a problem that we're trying to solve here, but it's just like a whole lot of other things. It just happens to be, frankly, a lot more complex, and a lot of the things that we take up, we're trying to figure out how to solve this problem.
If I could, Mr. Chairman,
please.
One last comment. Georgia came appropriately so, light years in terms of its taxation policy regarding marketplace facilitator last year. Obviously, it put on a level playing field, and my friend Mr. Busey made reference to a term parity. Georgia did the right thing. We said that there should be not a disparity between how we tax physical retail locations and online marketplaces. And while I acknowledge and understand that those are different, one physical, one online, it would seem to me a strategic step backwards were we to begin to again differentiate when we have something like, how do we make certain that criminality, fraudsters, and bad guys do not operate on either platform? And let's make certain that we have a level of consistency and equality and fairness about how things are applied. And that, again, we just don't want, we're asking not to go backwards in terms of what was the right step forward in terms of making certain that brick and mortar and online were treated exactly the same way in as many instances as humanly possible.
Sure. You know, and again, this isn't so much for you, but for the benefit of anybody who's still listening after our long hearing here, you know, as we look at possibly ways to make this more precise and more direct, you know, if there's something to consider here and there's something that we can move forward on, you know, when we look at, you know, I spoke earlier about products that are typically the subject of fraud or whatnot, but then another level might be to look at a price threshold. If you sell items that are valued in greater than excess or in excess of blank dollar, you know, that I think that there are ways to achieve what this is seeking to achieve without it being as broad as it is. Now, I'm not putting you on the spot and asking you whether or not you support that. That's not what I'm doing. And you and everybody else has every right to we ask you to give your input on, you know, we can't do our job without understanding this issue 360 degrees all the way around. But, you know, again, as I think out loud here, I think that that's another way that is, as far as trying to figure out how to reduce what we're trying to do in scope, that creates a fair level of accountability and consumer protection, but that doesn't create untenable obligations on consumers. And whether or not we can do it, I don't know. But we will keep talking. Is there anybody online that has anything they want to add for the good of the order? Anybody in the room have anything to add? Thank you, everybody. This was a long hearing, but we needed to hear these issues out so that we can understand them. And this hearing is adjourned.